Hello, I am Claire Milton, the University Secretary, General Counsel, and Privacy Officer here at St. Mary's University. Thank you for joining me today to learn about access to information, privacy, and confidentiality. I'm going to use the term FOIPOP throughout this module. This refers to the Freedom of Information and Protection of Privacy Act in Nova Scotia. This is legislation applicable to all public sector bodies, including universities, and it allows for access to information and the protection of privacy. Every public body in Nova Scotia is required to have a privacy or FOIPOP administrator. That would be me. Under the legislation, I respond to access to information requests, I maintain records relating to the FOIPOP requests, and I provide information to the university community about privacy. This presentation provides basic information about the law and some best practices for people to follow to ensure that we, being all employees and staff at the university, protect personal information. This webinar is divided into two sections. The first section will provide a basic overview of FOIPOP. You will learn some of the basic rules and what your obligations are as employees of St. Mary's University. The second section provides some tips and best practices on protecting privacy and personal information. St. Mary's University is responsible for substantial amounts of personal information. As you can imagine, we keep information about students, faculty, staff, alumni, and donors. Protecting this information is a shared responsibility of all SMU employees. We live in an age of information sharing. Unfortunately, this means that it's easy for people to become complacent about privacy and information security. However, we all have the right to expect that our personal information will remain safe and secure. Protecting the privacy of personal information is required by law, and it's a shared responsibility. The trust of people who know that we keep their personal information, our university reputation, and our exposure to liability all requires vigilance with respect to the protection of personal information. So, what is personal information? It is defined in the legislation, and it's extensive. Personal information generally means recorded information about an identifiable individual. This can include the individual's name, address, telephone number, the individual's race, their religious or political beliefs, for example. It can include their age, their sex, their sexual orientation, marital status, family status. As well, it can include an identifying number, symbol, or other particular assigned to the individual. For example, your A number is personal information. It also includes things like fingerprints, blood type, or inheritable characteristics. This is not information that we typically collect, as you might contemplate. This refers to the type of information that may be collected by a health authority, for example, or a doctor's clinic. It also can include information about an individual's health history, including anything to do with a physical or mental disability. And pertinent to the university, it includes information about an individual's educational, financial, criminal, or employment history. It can also include anyone else's opinions about the individual, and it can include your personal views or opinions, unless they're about somebody else. The extensive definition of personal information is included in the FOIPOP Act. It's important to note that it covers recorded information in any form. So it could be in print or it could be in digital format. As long as it's recorded, it's subject to the Act. The FOIPOP Act in Nova Scotia is similar to legislation in other provinces, and the federal government also has laws to protect the privacy of personal information. However, it is the Nova Scotia legislation that applies to the university. You'll find legislation like this across Canada because it's important as a public policy matter to allow access to information that's held by public bodies. The legislation, you will find, tries to balance the right of an individual to have access to information held by public bodies while also protecting the right of individuals to protect their personal privacy. This is a balancing act between access and privacy. Records in the custody of public bodies are generally accessible to people who want to see them. On the other hand, public bodies have to be careful to protect the privacy of your personal information if it is in the custody or control of a public body. So we need every employee of the university to help us protect the privacy of personal information. At the same time, every employee is required to cooperate with the privacy officer, me, if I contact you with respect to an access to information request. Let's spend a little time talking about what is a record. The FOIPOP legislation applies to all records in the custody or under the control of St. Mary's. A record is documented or fixed information. It could be correspondence, it could be video, it could be emails, it could be information contained in a database, or any other source of recorded or stored information. Individuals, and by individuals I mean any member of the public, has the right to request access to their own personal information, to view this information, to ensure its accuracy, and to request correction of errors. At the same time, anyone can apply to the university for access to a record if they think it's in the possession or custody or control of the university. One question that comes up from time to time is whether or not it applies to records that might be on an employee's personal device or in a personal email. If the employee does university work on a personal device or email, that record must be produced in response to an access to information request. From time to time, we know that employees may use a personal email address for the purposes of conducting university business. If it's university business, it's a university record. And therefore, if the record is requested, you may have to provide it even though it's stored on your personal email or personal device. The FOIPOP process can get fairly complicated. The process does allow for charging an applicant the cost of producing the records if they're extensive. This is not something the university often does, but sometimes we'll get a request that requires so much time and resource to respond to that we may need to charge a fee in order to respond to that request. However, if you are asking for your own personal information, a fee will not be charged for that matter. Anyone and everyone has the right to request access to their own information without charge. And as I said, you have the right to view your own personal information to ensure it's accurate and to request correction if you think there is an error in that information. As I mentioned, all records in the custody or under the control of St. Mary's University are subject to the Act. Sometimes you'll hear people say, these records are FOIPOPable. This is an example of a term that has been made up to describe the FOIPOP process. The criteria that we use to decide if a record is in the custody or control of a public body go beyond the physical location of the record. It involves factors such as the purpose of the record, who created it, and whether or not it relates to the public body's mandate or functions. Recently, the university introduced an email policy that requires the use of SMU.ca email addresses for the conduct of the university business. One of the reasons for introducing this policy is to ensure that the university can actually have access, custody, and control of university records that might be subject to the FOIPOP legislation. I'd like to emphasize again that privacy protection is everyone's responsibility. Although I'm the privacy officer, I can't ensure that the university complies with the legislation on my own. It requires everyone's vigilance and everyone's awareness of the requirements of the Act. The privacy rules in the legislation apply to the collection, the use, and disclosure of personal information. We maintain all kinds of records that include personal information as a routine part of our operations, and every employee plays a role in ensuring we meet these legal requirements. It's a balancing act. We have a duty to assist people in accessing the records that are held by public institutions. However, we have to at the same time be aware of the duty to protect personal information. This legislation is intended to support this balanced approach of access to information. At the same time, we have to ensure the protection of personal information. So when we, primarily me, responds to an access to information request, I have a duty to assist the applicant. The law says that we must take every reasonable effort to assist the applicant by responding without delay, openly, accurately, completely. I have to respond promptly. There's a requirement that a response to an access to information request be made within 30 days unless there are extenuating circumstances. I need to help applicants identify responsive records. If their application is not that clear, I can't dismiss it. I have to work with the applicant to help them clarify exactly what it is that they're looking for. I need to tell applicants about everything that might be available that is responsive to their request and give them a complete response. However, if a request is for records that include personal information of individuals other than the person seeking access, and in other very limited circumstances, we may have to refuse access to that information. So what are the basics of privacy protection that you need to be aware of in your role here at St. Mary's? First of all, we cannot collect personal information unless we're authorized to do that. The authorization comes under Nova Scotia privacy laws, and it can be collected only in these circumstances: when expressly authorized by law, for law enforcement purposes, or because it is directly related to and necessary for an operating program or activity. For example, for a university, it is necessary to collect personal information from applicants to the university. When we ask people for personal information related to an admission decision, the application makes it clear that we are collecting information for those purposes and that it won't be used for any other purpose. When we do collect personal information, we have to make sure that it is securely maintained. We have to make reasonable security arrangements against risks, including unauthorized access. Only those persons who need to know that information should have access to it. The collection, use, disclosure, and disposal of personal information has to be carried out in a way that protects the privacy of that personal information. Okay, so now I'm going to move on to some best practices, some things that I'd like you to think about as you're carrying out your daily work. First, what is a privacy breach? A privacy breach occurs when personal information is collected, retained, used, or disclosed in ways that are not authorized by the Act. Common examples of unauthorized disclosure of personal information include things like sending communications to the wrong recipient. This happens quite innocently sometimes when we send an email to a person other than the one to whom we intended. Unauthorized disclosure can occur from improper records destruction procedures. Sometimes confidential information may not be put into a shredder box, for example. It might just be put out with the regular garbage. This is not best practice. Loss or theft of unsecured devices such as laptops, smartphones, digital cameras, portable storage devices. USB sticks, for example, they get lost. We generally discourage the use of USB sticks unless it's absolutely the only option. Now that we have the Teams environment, it's possible to share information and presentations, for example, without having to resort to these small storage devices that are easily lost. Unauthorized access can also happen because people do snoop, and sometimes innocently. For example, they may think it's a good idea to look up a coworker's birthday. This is not a business purpose, and therefore it's an unauthorized intrusion into personal privacy. Unauthorized sharing also can occur. For example, if personal information is provided to somebody who doesn't have an authorized need to know or a business reason for knowing that information. So what are some best practices? First of all, obviously, we must limit access to personal information to those people who need to know it in order to fulfill their job responsibilities. For example, you may be an administrative assistant in a department, and you may be responsible for completing payroll forms in your department. Therefore, you're going to have access to the personal information of employees. You must treat that personal information in accordance with the legislation. It's possible to password protect sensitive records. It's also a good idea to keep sensitive records in secure databases. This is possible using the Teams environment. It's also important to comply with password best practices. There are tips about this on the EIT portion of our website. Use strong passwords. Don't use the same password for everything. All of these tips can help you protect the integrity of people's personal information. And certainly do not share passwords unless you're sharing a password to a document with a person who's authorized to look at that document. And again, please follow all EIT policies and guidance on passwords and security. Some best practices with respect to technology. Update your operating system when prompted. This should happen automatically, but some people have settings and they get pop-ups and they decide that they don't want to proceed with an update because it will distract them from whatever it is that they're doing and take up time. Don't do this. Allow for these updates because they often include important security patches. Complete your cybersecurity training. From time to time, EIT will invite you to participate in this training. It's important. It helps you to identify and report suspicious emails and other cybersecurity issues. And simply double-check your email addresses of your intended recipients before you hit send. In our Outlook email system, we have these convenient little tools. For example, sometimes you start typing an address and you'll get pop-ups of predictive names that the software thinks that you mean to send to. This is sometimes or always the reason why things end up going to the wrong person. For example, from time to time, I get emails addressed to Claire with a different last name because people saw the Claire and assumed that they had found the right person, but it wasn't the right person. So be vigilant in this regard. One of the things that helps make it easier for people to identify you is to include a profile photo in your email and your department icon for your email account. This helps people recognize whether or not they've found the right intended recipient. Unfortunately, despite all these best efforts, sometimes you might find yourself in a situation where you have sent personal information to the wrong person. What do you do? First of all, you need to follow the privacy breach protocol. You can find this on the privacy pages on the SMU website. There's a form, and if you have any trouble figuring out how to find that form or what to do when you suspect that potentially there has been a privacy breach, please just reach out. Please call me, Claire Milton. I can be reached at 6565 or on Teams, or you can also send an email to privacy@smu.ca, and I'll help you through the process. What are some more best practices, particularly with respect to mobile devices and working from home, as many of us do now, either in hybrid or permanent structures? Your mobile devices, they too need password protection, and many of us now are using multi-factor authentication, which is very useful in protecting information on our mobile devices. And again, I can't stress strongly enough that it's important to avoid using USB devices. Sometimes it seems like a very convenient thing to do, but they are prone to being lost, and it's just always better to pick a different alternative if you can. If you're working at home, I'm hoping that you're using SharePoint or Teams to share information with your colleagues when you need to. Since adopting the Teams environment, it's become much easier to protect the security of the information that we share with our colleagues. Also, you should be minimizing paper records. There's very little reason anymore to print documents. Paper gets lost, misfiled, and potentially does not get disposed of properly. There are still a few things that potentially have to be kept in paper format, but they would be the exception to the general rule that electronic records are easier to maintain and are better from a security perspective. As well, always secure your personal devices. Never leave them in your car. I know sometimes you have to stop on the way home for some reason. If you have to do that, please make sure your laptop's not visible in your car. And of course, if you do lose a device, you need to report any lost or stolen device immediately to EIT. They have the tools to ensure that information stored on lost devices is not accessible to anyone that finds the device. So it's important that they know about these circumstances as soon as possible. Lastly, if you're dealing with confidential information on a regular basis, and if you need to talk to colleagues about that confidential information, please ensure that you're doing that in a confidential space. These conversations that may involve the personal or confidential information of other individuals shouldn't be shared in a space where other people who are not entitled to hear that information may in fact overhear it. Some simple little things can also help in this regard. Maintaining a clean desk, locking your cabinets if you are keeping paper records, shutting down your computer if you do have to leave it behind, shredding confidential paper as mentioned, and using privacy screens on monitors are useful tactics. If you're not familiar with privacy screens, they're inexpensive screens that can be placed on computer monitors that mean that only the person who is directly in front of the monitor can see the information on the screen. Depending on the nature of the work that you do, this may be something that you should consider using on your computer screens. A last word, I'd like to talk about recording. I get a lot of questions in recent months about whether or not it's okay to record meetings and conversations that happen in the workplace. There's no absolute answer to this question, but it is important that we know when and when not to record meetings or conversations. Do not record anything without permission and the consent of the people involved in the conversation. Do not record meetings without notifying all those present that the meeting will be recorded. Recording in secret or without disclosing to others involved in the conversation or meeting that you are recording endangers personal privacy, and it certainly does nothing to the trust relationship between you and your colleagues. Unauthorized recording of work conversations may breach the confidentiality of protected and sensitive information. It's just not a good idea to make a recording if you haven't sought the consent and provided notice to all those present. When using the EIT systems of the university, email, Teams, etc., it's also important to know that your own expectation of personal privacy is limited. When you're at work, you need to be aware that you're using university business systems, and you should not be using them to conduct your own personal affairs or personal business except on a necessary basis. And you should be aware that potentially that personal information will be seen by others. So generally speaking, as is set out in EIT policies, your use of university systems for personal reasons should be a limited and exceptional occurrence. In this regard, please take a look at Policy 22004. It's the Policy on Information Technology. It's available on the website. It states that we must limit the personal use of university IT to modest, infrequent purposes. As well, take a look at Policy 22006. This is the email policy, and it states in general that email is not appropriate for transmitting sensitive or confidential information, including personal information, unless an appropriate level of security has been assigned to match the sensitivity of the document. There are lots of resources available to you to learn more about privacy and information security. On information security, you will find information on our website on the EIT information security pages. There's security education information awareness information on the website as well. Under Security Awareness Education, you can find it using that term on the website. And there's certainly lots of information on the website about cybersecurity while working off campus. And at smoo.ca, privacy, you'll find more information and this presentation about the whole area of access to information and privacy. So I hope you found this information helpful. At any time, you can always contact me and ask me questions about privacy and confidentiality or access to information. You can write to me at privacy@smoo.ca or at claire.milton@smoo.ca. I'm always here to answer your questions, and thank you for being here today.